Good afternoon. I'm Dr. Liesl Bryant, and I'm one of the risk management advocates for the Trust. And I'm delighted that you're able to join us today for our 28th Risk Management Roundtable. As a Trust policyholder, most of you are likely familiar with our risk management consultation service, the Advocate 800 program. It's one of the many benefits our policyholders receive through the Trust. I'm one of those 8 advocates, and I'm excited to be joined by 2 of our other advocates, Dr. Mark Martinez and Dr. Dan Taub today. All right, so on that note, Dan, I'm going to start with you, and I want to go ahead and start with some questions on records. As you know, we've been getting lots of calls on record keeping, and I'm going to ask you a couple of questions on that, but starting with this first one, in part to provide foundation to the second one, I want to ask if you can clarify what are some of the core underlying purposes as to why we have to maintain records?
Sure, Liesl. Good question. And, I think it's one that many of those of you who are here today already are familiar with underlying ideas, but it's a great place to start, okay? And the core aspect really is about care for our clients and patients and continuity of care, both between clinicians, if one has to transfer a case or is going to be on vacation or becomes ill, and also within, that is, from one session to another. I suspect that many of you here today may have close to exact memories of what transpires in each of the sessions you do. And having had that capacity earlier in my career, all I can say is this too shall pass. So records are very helpful to have, particularly as our memories begin to change. They help us understand and be able to think about the trajectory of treatment, what the setbacks may have been, how progress is happening, what works in a session. Of course, a second general aspect has to do with those of us who are involved in the third-party payer system. And it's essential for the survival of our businesses as professionals, okay? And as fraught as that can be at times, the third-party payer system allows many people who would otherwise not be able to afford our services to be able to get those services and to get the care that they need. Again, not a surprise to most of the folks here today, but record keeping is an essential component to risk management. As the old saw says, if it's not written down, it didn't happen, right? Another aspect of risk management and record keeping is that it allows us to slow down, to reflect a bit on what was the session we just conducted, what happened there, how did we evaluate the client's statements and behavior, and if any risks arose that we needed to address, what were the actions we took or we planned to take or we decided not to take. So documentation helps us, as the Navy SEALs put it, engage in slow is smooth and smooth is fast, okay? Now, of course, records serve another purpose, Liesl, of reviewing quality of services when we're in mental health systems, but also for those of us who do supervision, they can really help us orient toward and know what's happening in sessions in another way, in addition to, for example, watching recordings of an occasional session or being live, doing live supervision. And the last kind of aspect of why we do these is that there are legal requirements in many states, although there's some debate about whether HIPAA may require certain aspects of records. It doesn't speak to any content. That happens basically at a state level. What is a federal rule that applies is what's called the information blocking rule, which requires those of us who have electronic health record keeping systems that have client-facing portals, and where that is feasible for us to do, to allow for immediate access to records when once they're completed. And when those records are crafted well with an orientation, for example, as the British National Health Service does, toward really trying to have it be part of the alliance and engagement, there's some research suggesting that alliance and engagement can be improved, as well as trust. If we don't do the records sensitively or in a manner that is perceived in a fashion that is somehow derogatory or judgmental, they can also be quite damaging. So those are some basic aspects and reasons for the rule, why we have to keep records.
Great, thank you. You covered a lot of useful information. I'm going to come back with a second
Okay.
question, but Mark, do you want to add anything to that before we?
I think Dan did a great job covering a lot of the high points, especially like his comments on using it as a tool to process and to reflect on what occurred in the session, not just to memorialize what happened. And I think that's especially important. It speaks to the timeliness of our records as well, to be able to take advantage of that process of reflection and processing what happened, perhaps even use it as a tool to learn. Um, we're going to benefit most when it's done in a timely way, because we're going to lose a lot of that rich data the longer we wait after the record.
Mm. Yeah, I appreciate that both of you mentioned that, because I think sometimes it can so often feel like, gosh, I got to get to my notes, and it just feels like this, paperwork thing that we just task that we have to conclude. So nice to also see it have value in other ways. So, okay, great. Mark, I want to turn to you to talk for a moment about artificial intelligence, or AI, because as you know, it's becoming more well known. We're getting many more calls about that. And there's lots of benefits and some risks, right? So can we start, if you'll start just by telling us what are some of the primary risks associated with starting to integrate AI into our clinical practices?
Yeah, and I think you hit it right on the head that we want to proceed with caution, because there certainly are a lot of risks, and we don't want to get caught up in the blessings that may come along with AI and negate the risks or forget about them. So some of the uses in clinical practice may include, but certainly are not going to be limited to, preparing a transcript of a therapy session, or assisting with note taking or report writing. It could even be used as a tool to assist us with diagnostic clarification or treatment planning, or even behavioral monitoring. But before you implement AI into your practice, it's very important that you're aware of the very real threats to data privacy and security that this tool poses due to the sharing of sensitive patient information, especially if it's not properly managed by the AI platform in a secure manner. Another important consideration relates to biases in the AI algorithms. And these can result from the fact that AI is often scraping or training itself on unrepresentative, incomplete, or even incorrect data. So we have to remember that the accuracy of these systems is variable. And this really requires us to consistently review whatever the results are, the output, to prevent errors. And we have to appreciate that some of those errors can be harmful to service recipients, especially those who are from demographic groups that are disproportionately marginalized or not well represented in the data that's being relied upon by the AI system. Next, the lack of human oversight in AI decision-making can lead to serious errors in service delivery and record keeping. So this highlights the importance of maintaining clinician oversight whenever you're using an AI tool, and using them as a supplement rather than as a replacement. And then lastly, of course, the AI advancements are occurring extremely fast. And so this is going to put the burden on us, if we're going to use these tools, to remain informed and respond to emerging issues. And that is going to require some diligent effort on our part to make sure that we remain competent.
Yeah, great, thanks. And sometimes that's a heavy lift because there's a lot to learn. Dan, anything you want to add there?
Yeah, I just want to underscore, I really think you've covered the highlights, Mark, and I want to underscore just how careful you have to be around what's called hallucination by artificial intelligence. There have been many cases out there that are already in the news, two of which just briefly mentioned. One is a parent who is suing an AI provider because the AI apparently encouraged her teenager to take his own life. And so it went clearly way off the rails. Now that's publicly available. There was another fascinating study, a very simple study published in, of all places, in the Turkish Journal of Psychiatry a couple of years ago, where the writer, the psychiatrist, actually put the actual references that he used for the article in one section, and then he put the references that AI gave him in another, and half of them were made up. So you have to be really careful. AI is a lot like humans in this way. It doesn't know something, it just makes it up.
Mhm. Mhm.
And it can be dangerous.
Yeah, that's a great point, and you give two very good examples there. And I think relevant to that too is also what Mark had said about bias, right? So we have to be able to spot the quote unquote hallucinations. We also have to know the literature so we know when bias is showing up and when it isn't, right? And so that also puts more of a weight on us to be sure, like you say, human oversight, but we have to really know the literature if we're going to start to count on AI to do things like assist with diagnosis or risk assessments or those kinds of things. So, all right, I'm sure we're going to get into more details with some questions here. So I'm going to move us on. But Dan, I want to come back to the question about record keeping because, in particular now with some of that, we're getting lots of calls with some of the tension around needing to keep records for all the reasons that you said earlier, but also really wanting to safeguard patient privacy. And in a lot of instances, we've had a lot of calls where clinicians are saying that patients are requesting to have their records deleted or those kinds of things, right? So this real sensitivity to how do we document and meet the requirements we need to meet while also safeguarding patient privacy. So that's just one aspect, but if you can give us some guidance for how do we do that, right? How do you do documentation that's sensitive and useful and appropriate?
So, it's very much a theme currently, as you pointed out, Liesl. But how we document sensitive information is a traditional tension in records. And it's a tension between what's required, as we've talked about just a few minutes ago, and also the privacy interests of clients. And the reason is that, of course, over many, many years, other systems and people other than the client or patient and the psychologist seek and often will get access to records. And because of that, this tension is actually something that has a fairly long history. Just some examples before I get into the current situation. Many of you here today have had subpoenas for records, okay? Or you've been called to be deposed about what's happened in a clinical case. We may get a request from schools or from parents to send records to schools regarding their children or adolescents to help to decide whether the youngster meets standards for the IDEA and special education, or custody evaluators, whether we see adult individual patients or couples or families or children who are seeking records to help in their development of recommendations for parenting plans, custody plans. And I know that there are people here today who have been asked to provide information so that determinations of fitness for duty as a firefighter or a pilot can be completed. And clients themselves ask us to do things like completing FMLA paperwork or disability coverage paperwork or applying for life insurance. So this has been a tension with a long tail. Okay. Of course, what's heightened it currently is that with concerns about the vulnerability of folks who have non-binary gender identity or are exploring that, concerns about folks who are immigrants who may be here legally but are very concerned about being deported. Uh, it has heightened the current concerns about how much do we put in a record. And if I'm borrowing here from an article I read locally in the San Francisco Bay Area from a physical therapy practice, and it was really from an idea about how do we best improve our strength and flexibility, which is an interesting metaphor here, when we've been injured, right? And what they talk about, and what I believe is one of the guidelines for us, a key guideline for us in doing records, is the Goldilocks standard. That is, not too much, not too little, just right. And doing records like that takes more time and effort. It's not just writing whatever happens to come into my mind, okay? And, apropos, Mark, of your conversation about artificial intelligence, when we have summary apps, some of the concerns are that they might include all kinds of information that we don't really believe is necessary or that we believe should not be put in a record. So even when we're using some kind of assistant and we've assured its privacy, we have to be very thoughtful and intentional about balancing, about using this Goldilocks rule. And the underlying idea with respect to the Goldilocks standard is what is the necessary information in order to address continuity of care, legal requirements, risk management, and medical necessity? What are the minimums? Okay. So for a low or moderate risk client, someone you don't have daily concerns about, or who hasn't had a spike, for example, in suicidal ideation, notes that are lean can provide plenty of continuity of care and demonstrate, for example, medical necessity. Say I'm working with somebody who has a generalized anxiety disorder, and I say we continue to focus on anxiety and its interference in their interpersonal relationships, interventions that I've used. So it can be very simple. It doesn't have to be highly complex. Um, and there's little need to go into detail about why, for example, the person has that anxiety. Now, if one's memory is like mine, you may need a little bit more detail. But again, there's still going to be this idea, do I really need this in order for me to have continuity of care? And what kind of privacy risk does it potentially pose to the client or patient? And even with higher risk patients and clients, which traditionally, Liesl, Mark, you know that we've recommended for years that when there's high risk, we write more rather than less. But even there, the focus of our documentation is not going to be writing everything. It's about the focus on the risk that's elevated, our plan after we've assessed that risk, and the logic between the two, and then what our course of action actually was. But unless the information is really essential for us or necessary for determining risk, we are allowed to and can use our discretion about leaving it out. So to summarize, Liesl, I'd say the Goldilocks rule: not too much, not too little, just right. What is truly necessary?
Yeah, I love the way you put that. And I do want to just mention, so the Goldilocks, what's just right might be different in one case than another case, right? So
Yeah.
I do want to highlight just the real need that this is an individual case by case consideration. And I also just want to say, when we, all three of us here, give examples, remember that those are just examples. So you want to really individualize the case note. And Mark, did you want to add anything?
The only thing that I think to add is when you're learning exactly where that Goldilocks rule falls for you, I think you want to really, you can't underscore enough the importance of consultation. I think because, especially at the outset of your relationship with a new patient, finding out where that gauge is set, how to weigh the context and what's appropriate, not too little, not too much. You may be able to, in a de-identified way, seek counsel or consultation with an experienced colleague. And then after a while, I imagine that you'll get that just right gauge and you'll be on your way.
Mhm.
Yeah, that's a good point. And I also want to add, I think it's, the patient may have their perspective, right? There are some clients, say, who have very high security level clearances that may want much less than, and so finding that middle ground or that Goldilocks part for them too. So taking into consideration what their needs may be, and some of the examples Dan gave too.
Lisa, if I can just chime in just briefly before you go to Mark again, and that is that, another really good example is what I think all three of us have experienced a lot in the past few months, which is with the initial floating of the idea of an autism registry, which, by the way, some states do have and have had for years. And the concerns that parents, as well as adult people with autism, have shared, and really saying, does this really need to be in my record, right? Among other things.
Yeah, no, that's a great example, and we've had a lot of concern about that.
Yeah.
So I think some of this is just highlighting how we need to give real thought to what we're putting in, right? And not just sort of do what we've always done, but to really give some thought to it, both considering our needs and the client needs as well. So yeah. All right, Mark, back to you on AI for a moment before we move into some of the live questions. And I know right before you mentioned some of the risks. So I'm hoping now you can speak for a few minutes about what are some of the steps that practitioners can take if they do want to incorporate AI into their practices. How can they mitigate some of those risks, or what should they be thinking about in that regard?
Yeah, so as I mentioned, integrating AI does come with several risks, and I touched upon data privacy, security concerns, some of the algorithm biases, and over-reliance on the results without appropriate oversight. Yeah. To mitigate these risks, I recommend practitioners consider the following, and these would be, I think, overall as a starting point, jump off point. But first, I want to emphasize it is very important that you do not use open system AI platforms for patient data. And when I say open system, an example may be ChatGPT or Copilot, because even if we are inputting data that we consider to be only non-identifying information, there are some findings that AI systems may still be able to identify the patient using this information based upon your location and some of the case specifics. And so it may not be as private as we intend it to be just because we feel like we're de-identifying. But in terms of AI use incorporating into a practice, it's important that we begin by assessing the AI's appropriateness for your particular practice. Ask yourself, is there evidence that supports its effectiveness for the task that I want to use it for? Is it cost effective even for your practice needs? And if you do identify an AI platform, you want to make sure that you obtain a business associate agreement. It's often referred to as a BAA. And you want this signed by the AI platform. And remember that not all BAAs are created equal. And so ensuring that it provides adequate protection will be necessary. And to accomplish this, if you're not familiar, you can locate a sample BAA that's provided by the Department of Health and Human Services through basic web search. So if you simply search for sample BAA and you look for the hhs.gov site, you'll see a PDF. By reviewing that, you can get a sense of the components and a solid BAA may look like. Alternatively, you can have a healthcare attorney review the BAA and use their feedback as a guide on its comprehensiveness or perhaps its shortcomings. Now, it's also important that you review the AI platform's terms of service and their privacy policy to understand how the information you enter will be protected or maintained by the company, as well as find out where it will go. Will it be housed internally, or do they share it with third parties? And if they do, how do they do it? Do they encrypt it? Do they de-identify it? Is there a process in place? And if the content of these documents is unclear, again, seek clarification from the company or consult with somebody who's experienced in this area. Next, providers should routinely review results obtained from AI to ensure, again, their accuracy and applicability and remain vigilant for potential biases. And as Liesl said, this is going to require you to be familiar with the literature so you can pick up on these things. Providers must remain aware that ultimate responsibility for the decisions made fall on the provider, not the AI platform. Again, it should be used as a supplement or aid rather than a replacement. And providers should understand that errors in AI can have serious repercussions that can harm service recipients and not just harm them, but tarnish our professional reputation in the field in general. And when using AI, providers should incorporate information about its use into an informed consent. You want to explain the information related to AI and its use in your practice in clear, simple terms, and also provide the option to opt out if a service recipient is uncomfortable with its use. Those using AI should maintain competence through consultation, training, continuing education, and this would be an ongoing practice because we need to stay on top of it. And providers who employ other professionals who plan on using AI or are using AI should ensure that they are using it appropriately, have the appropriate training themselves. And you want to document this in personnel files and routinely revisit to make sure that they are staying abreast of new developments. And then finally, providers using AI should monitor legal and regulatory developments that may affect the use of AI generally and specifically released to healthcare settings.
Great, you covered a lot of info. Dan, anything to add to that? Great job.
Yeah, Mark, really good review of the ways we have to be careful. The one thing I want to highlight of what you said is that it can be, you use the word scrapes, which I think is so important, that the way that AI learns, because one of the characteristics, the fundamental characteristics of artificial intelligence is that it learns without human activity. So it's learning everything from the data that it collects, and the AI that we see in large language models like Copilot and ChatGPT are scraping, as it's called, the internet, literally searching out the internet for all kinds of information, false and true. We all know how tricky the internet is in terms of differentiating what, particularly with AI's creation of all kinds of information as well. And part of the challenge that all of us have in adopting AI for our practices, for whatever functions you'd like to use it for, is that we have to be careful and find out, how does the company train their AI? Do they train their AI on all of the data that they're collecting from all of the patients and clients whose therapists are contracting with them? If they say no, how are they training it? Because to improve, the AI has to continue to learn. So that's one dimension of the scraping, Mark, that I just wanted to highlight. Really good point that you made.
Yeah, and I really appreciate that you mentioned that, Dan, because I want to just highlight, and then we are going to get to live questions here. But I think, and Dan and Mark, feel free to disagree with me if you do, but I really think in order to use AI in our practices at this time, it requires a fair amount of work, a fair amount of homework, a fair amount of really understanding the technology, which for most clinicians is not super easy. I know I've talked with a lot of clinicians who aren't even sure what kind of questions yet to ask. But really important that you ask them, right? And I think, Mark, to your point of understanding the terms of service in BAA, I know of several cases where the ways, the video, the audio transcripts of entire sessions, which were only supposed to be used for summarizing notes, eventually got used in very different ways. That was allowed by the terms of service, but the clinician didn't know. And then it led to some real problems. So we really have to know a fair amount before we say yes and before we start using these things. And last thing I want to underscore is just your importance of, Mark, you said, including it in the informed consent so that patients understand where their data is going, who has access to that data, and have an option for opting out. So I'm sure we'll get additional questions and be able to say more, but let me turn now to the live questions. And it looks like we have a couple here that are not on either of the topics. So we'll be jumping around for just a few minutes. And Mark, I'll start with you with this one. So the question is, when a client requests booster sessions after a period of not being seen, at what point would you want them to re-sign your informed consent documents, assuming that there's not been any significant changes in the informed consent? Yeah.
Okay. So based on the question, my impression is that, as you said, this is a patient who hasn't been seen in some time. And I think right there, that's where some red flags start going off for me, because it seems like a potentially risky situation if that is not something you've agreed upon with the patient. I understand some patients may receive a session every couple of weeks or perhaps once a month, or you're in that booster phase. But if we haven't heard from them, that's not part of the treatment plan. I think there's some risk that you are going to be exposed to, because the argument is something happens to them that you're unaware of, you still could be very well considered to be responsible for their care. And so the reason I'm highlighting that is it's important to think about your caseload, the contacts, how well are you up to date, up to speed on the patient, how well they're doing. And if you haven't heard from them at some point, reestablishing contact or an ethical discontinuation of treatment and perhaps transferring their care, or it's not the right time for them to continue treatment. That way you have a nice formal end care. And if they did come back to treatment, then you, of course, you go back through the informed consent process. It may be more abbreviated than if you have a new patient, but I still think it's extremely important to engage in that informed consent process, not just hand them a form, say, sign this, and throw it in the record, and then you're off to the races. You want to make sure that they do remember the important parts of confidentiality limitations, expectations, and so on. So I'm afraid I may have dodged the question a little bit or answered it in a different way, because I think I have a little bit of discomfort because of my low risk tolerance if we have a patient we haven't seen in some time. And so for me, I think the answer would be more in making sure that the case is, this is something that's related to treatment planning. And if not, that you're appropriately closing the case and then reintroducing them back and going through the informed consent process once again.
Mhm. Dan, any additions?
Yeah, no, I actually don't think you dodged it, Mark. I think the longer you go having not seen someone, the greater the likelihood of something changing. And the client or patient may not think to tell you. Also, things can change for you. What happens if I now am adopting AI and I didn't 6 months ago when I last saw the patient? I have to redo informed consent. So I think the idea would be one still assesses for changes. You do the formal, you kind of do all of the intake, but you look at it and you say, what kind of changes have happened? And consider whether there are changes in your practice. Because we may be very good psychologists, but we are not yet psychics. And so as a result, we can't really predict whether it's somebody we haven't seen for 3 months or 3 years, what has happened in the intervening time.
Right. And I think back to you commented on memory a lot this time too, Dan. Hard for us to remember, gosh, did I make that change to my informed consent document 2.5 months ago or 5 months ago? Or, so yeah, I think it's a generally good practice to both ask the client to review it, right? Do they have a new emergency contact or a new address or new insurance information, right? All that stuff changes a lot. And then even just to offer, here's my current form, right? And they can go through it. So I think it's a generally good idea too. Okay, Dan, I'll send this one your way. For telehealth sessions, is it still a requirement that we need to document the client's address, nearest emergency room, etc.?
Yes, yes, and then again, yes.
Yes. Okay, great. Very short answer. Excellent. I love that. Okay, Mark, coming your way. When providing a psychological evaluation during a forensic IME, we often have to review the psychological evals conducted at the request of opposing counsel. How should we handle it if we believe the opposing counsel is engaged in ethical violations? For instance, practice outside the scope of competence, undisclosed dual role issues such as performing evaluations on friends or family. I know you do a lot of forensic work, so
Yeah,
I'll let you take
yeah.
it.
I mean, these do come up to some frequency, and I believe when you say opposing counsel, I'm assuming you're meaning an opposing evaluator, opposing expert, perhaps, um, rather than the attorney. Correct me if I'm wrong in misinterpreting that, but this does come up from time to time, and I think sometimes we have to check our own biases because it is a highly adversarial system, and we're feeling scrutinized, and sometimes in return we scrutinize or perhaps overly scrutinize somebody else's conduct. So you want to be mindful of that. It's something that I always try to check myself if I have those feelings. But there are very real missteps in practice that occur in forensics, just like any other area of psychology. However, if you are engaged in active litigation, it could be considered witness tampering to file a complaint at that time. So timing can be very important. It doesn't mean that you don't file a complaint, but timing can be very important. And oftentimes the recommendation is to wait until the litigation part is done to pursue a complaint, or even if it's an informal resolution of your concerns. Stanley Brodsky has a nice article that I believe if you search, or you have a colleague who can point you in the right direction, but informal resolutions, and there are some sample in the appendix related to letters you can write to a colleague so that they can mull it over and perhaps get over the defensiveness and then be open to some of the feedback you're giving them. But I think during the course of litigation, very often informing the attorney you're working with about some of these concerns, and they can be perhaps addressed during the course of litigation and brought out in the open, and that can have a meaningful effect in terms of how much weight that expert's work is given by the trier of fact.
Yeah, Dan, anything to add?
No, just I think that informing retaining counsel or the folks you're working for, as Mark was saying, and they may choose to use or not use that information in trying to address the accuracy and reliability and validity of the assessment that's been done by the other side. And then, yeah, Mark, you're absolutely right. You have to wait. We can't get into witness tampering. It's one of the reasons Brodsky talks about writing letters usually after the fact to help our colleagues improve, particularly if it's not an egregious violation. If it is, then it may be appropriate to do a formal complaint when it's not appropriate for an informal one.
Mhm.
Yeah, and I just want to underscore too, this is a great thing where I think consultation is so helpful because especially in forensics, the cases can be a little messy, right? And it can be complicated. So, in addition to things like, as we've talked about, good informed consent, good documentation, good self-care, the other main, risk management strategy is consulting with a low threshold and frequently. So I think that's the additional thing to highlight there. So Dan, question for you. Let's say a client would like a transcript of our sessions for his personal use. What should the clinician think about before they agree to that or not agree to that?
Well, I think there are a number of factors, Lisa. One of them would be, what is that? What do they want that to be? What are they thinking about in terms of personal use? Are they planning on posting the transcript or they're recording on Facebook or Instagram or TikTok? In which case, I would not necessarily agree to that because it's also my information and your information. But as some of you have had over the years, I certainly have, some of our clients may really find it difficult to recall what happened in sessions. And sometimes the transcripts may be really helpful for them to review, for example, what we've suggested or what they were talking about because they find themselves leaving a session going, what happened, right? So it's the first would be what's the purpose, and to have that kind of be a primary consideration. The second is that if they're asking for a transcript, presumably it's going to be, that they are or you are going to record and there's going to be a transcript made or there's some maybe AI transcript being made. I would definitely encourage the clinician to review that transcript before releasing it because it may not be accurate. Anybody who's tried to do texting by voice to text knows how fraught it can be. And even though the systems are getting better and better, they still make plenty of mistakes. So the purpose would be the first question. The second question would be, is this accurate? A third one, not necessarily in this order, would be, what's the nature of this relationship? Is it one where the alliance is good? Does the person I'm working with have an ability to connect and engage? Or is this somebody who really struggles with their attachments and becomes very rageful, or on the other hand, becomes really fearful? And while we have an obligation, a legal and otherwise general ethical obligation to provide the records, we don't have an ethical or legal obligation to provide a transcript. That's really something that's a matter of choice. So I think the dynamic in the relationship, the nature of the patient themselves and their needs are factors to consider.
Yeah, great. I agree. Mark, any additions there?
I really like that the summary you provided, Dan, and I think the accuracy is really important. And once you have that copy, I think it'd be important for the treatment provider to maintain a copy themselves. That way, things can get, I hate to be cynical, but it's possible that that transcript could be modified. And so you'd want to maintain one accuracy and then retain that accurate copy for your own records. And I think that relationship component is really important. And during that process of speaking with the patient about this request, you can highlight some of the risks, some of the benefits. You can even explore some alternatives because after all, what they're after is they have a hard time remembering some of the important things or they find a lot of value in the sessions. There may be some alternatives that can help that memory aid process, like perhaps collaborative record keeping, or we're taking some time at the end of session to review some highlights, or perhaps allowing them to take notes, or you provide them with just a few of the highlights from the session that they can take home and they can rehearse. So I think that process of engaging the patient, having an open discussion, and then thinking about the potential uses, documenting everything, of course, and retaining your accurate records for your purposes, should they be necessary down the line.
Yeah, I think those are great additions. And I'll add one to it is just also, I think, having a conversation with the client about, if they're going to take a whole transcript home with them, they may want to be really mindful as to who then has access to that transcript. So, right, their own confidentiality keeping once they have that copy, and, they probably don't want to leave it out on the dining room table and that kind of thing. So reminding folks of that, I think, is useful. Okay, Mark, I'm going to send this next one to you. And there's actually two questions that I'm going to combine. They're a little bit different, but I think they're going to be relevant in your answer. So the first one is, what are your thoughts on risks associated or factors to be considered around the use of AI note writing software? And the second one, which is similar, with Zoom's AI companion, where does the private information about patient sessions get stored or deleted once used? Now, you may not know the specific to Zoom or something, but I suspect I wanted to include that because I think that's probably relevant for what you're going to say about questions about AI note writing in general.
Yeah. So to get out of the second part out of it, I don't know. I don't know where Zoom stores it. And so I think, but that's an extremely valuable question because that's one that you should have an answer to and then be comfortable with that answer. And so that's exactly when I was talking about not just the business associate agreement, but the privacy policy in terms of service. That's the type of information you want to have a good grasp of exactly what is being collected, how is it being used, where is it going, and if it's going somewhere, in what form, and what protections are in place to keep this information private and secure. And then the first part that the note writing software, a lot of the same goes to that answer as well. That again, starting with that business associate agreement, understanding they're not all created equal, so you spend some time with it. It's not one of those where you're probably going to review it once, sign, and that's probably not going to be enough due diligence on your part. You want to spend some time with it, really understand the terms, where the boundaries are, and learn about the company. Do they respect this data as much as you do, or as much as you would expect and hope? If the answer is yes, then I think, with caution still, you may move forward. But there are a lot of companies out there who are jumping on the bandwagon because this is a very popular technology. And they understand that there are a lot of people who want to make their lives more efficient, easier, perhaps do better, maybe, or at least that will be their argument. So you want to take very cautious, slow steps, learn as much as you can about whatever AI platform you use, and make sure that it's treating the data with just as you would expect another colleague to treat it, securely and privately.
Yeah, thanks. And I like how you underscore, again, needing to really understand the ins and outs. And in part, you're doing that so you, the clinician, can make that decision, but also so that you can then relay that information to your patient and informed consent so that they can make an informed decision. So if you don't have these answers, you can't really do a sufficient informed consent either for your patient. So Dan, any additions you want to add there?
Yeah, I won't single out a particular video chat platform, but if you look at terms of service for the popular platforms for mental health, and you also look very, very closely at the privacy policies, you may find in some of them that they say, we will not record, we will not have access to any of the video or audio. We just get metadata, who used it when, that sort of thing. But if you look at the terms of service, they say things like, if you use our AI component, we train AI on it. So don't assume if it's offered in Doxy or Zoom or VC or whatever platform, simple practice, that they're going to have the same policy for your use of AI that they do for the other data. So it's a great question, as you pointed out, Mark, and it really requires digging into privacy policies in terms of service for any such service you're going to use. Don't just click on AI and say, woohoo, I've got my summary or I've got my transcript, because you may just have given away all of the client's information, not only to the company, but as you pointed out earlier, the BAAs define who the business associates are, and they are legally permitted to share the information. So if my video chat platform has a business associates agreement with, say, the Department of Defense, they're going to share all the information with the Department of Defense, right? Department of Defense can purchase that information. They don't even need a warrant or a search warrant or a court order. So be really cautious. This is not a kind of woohoo, we can just make everything so efficient and don't have to worry about it anymore.
Mm-hmm. No, I agree. And I think that point about the third parties in a way, right? Who are the other companies that have access is really important. And I do know a lot of clinicians that are using it that don't know the answer to those questions. And that's where serious risk lie, and potentially real harm to clients. So, okay, Mark, I'm going to send this one to you first. It's both AI and forensic. So he says here, I have a colleague who uses AI for their forensic work. I'm wary. When using AI in forensic report writing, does HIPAA require a HIPAA compliant AI interface? Or is that not controlled by HIPAA because it's not treatment? So that's the first question. And then even without HIPAA legally controlling this issue, do we need to worry about sharing sensitive information on AI interfaces that are not HIPAA protected? I'm hoping folks can guess at the answer to that last question by now, but please repeat it just in case.
Right. So in the first part, there's a few HIPAA related considerations there. So one, are you a covered entity? That's one. If you're not a covered entity, then arguably, HIPAA's not going to apply. And there's going to be a big asterisk on this. I would still strongly recommend, I can speak about myself. I never billed insurance. I've always done forensic work. And so technically speaking, I wouldn't meet the criteria for being a covered entity, but I operate consistent with HIPAA because it's a really good risk management to do so. And beyond that, things that are creative or anticipation related to litigation is one of those exceptions under HIPAA as well. But I still think that maintaining the most secure and private practices are going to serve you and those who are service recipients best. So the answer is that it may not control, but even if it doesn't, it's still a very good idea to maintain those standards. And then, do we worry about sharing sensitive information on interfaces that are not HIPAA protected? Absolutely. Yes, you absolutely do. Just think about an analogy. If we took a patient's file and we were just to go downtown and just kind of throw it here and there and everywhere, we would think that's madness, right? Well, the same type of thing is happening, but in the digital world. And so we want to make sure that we are protected if we're going to be sharing sensitive information.
Great. And Dan, I'm going to try to get to a few more questions, but do you have
Sure.
anything to add right
No,
there?
why don't we go ahead
Okay,
with the
great.
question? Yeah.
So one question to you, Dan, is it necessary these days to keep electronic records, or can legal and ethical requirements be met with handwritten or paper records?
I'm actually a fan nowadays of stone tablets because the problem with electronic records is that if we concentrate data, we will attract, as you all saw in the Change Healthcare, debacle, attract ransomware folks and all kinds of bad actors. So while I'm joking about the stone tablets, you are and I am permitted to use paper, to use our own local computer, make sure it's secure, even if you're not having, as Mark was just pointing out, to be HIPAA compliant. We are not, as psychologists, required to maintain records electronically by law. We may, if we accept third-party payment, we may be told, look, the only way we do billing is online. So de facto, we may have to use it, but it's not a legal requirement.
Yeah, great points. And to your point, I actually have a few colleagues who now not only have gone back to paper records, but they're actually marketing that as a sort of key piece of their practice that is more private because they're not using EHR. So it's interesting, right? All right. Mark, this one goes to you. Do I need to have a BAA, Business Associate Agreement, if I am using a software system like Adobe that has AI, even if I'm not using the AI function? Let me clarify. Basically, if Adobe storing data of mine or my clients just by nature of me using the software, and are the typical compliance regulations insufficient?
Oh, I don't know if I have enough familiarity with Adobe specifically about how it gets stored in that platform. I think as a reader, but I also know that there may be settings in which if it is linked to an online account through Adobe that you get updates, that there could be versions of whatever you open saved online. And so if that's the case, if that function is present or if it's turned on, then yeah, you want a business associate agreement. And the AI feature, the same would go for that. I believe the AI function in Adobe is one of those that you can you can opt out of. You can toggle it so that it's not present or not active. And you want to make sure that that is appropriately selected. And if AI is involved in accessing the data, I believe, I'm not as familiar with it, but I believe it provides summaries of the ones that can be reviewed that have text reviewing capabilities. But if it is, then you certainly want a business associate agreement. So the answer really depends on what version do you have, how is it functioning, where is that data going, and learning more about exactly the answer to those questions. Because some of the older ones may not have that functionality, if it's just located on your physical device.
Yeah, and to be clear, I mean, it's hard for us to say specifically, yes, Adobe, no Adobe, yes, Zoom,
Yeah,
no
right.
Zoom. So we can't give those kind of recommendations, but certainly, Mark, all of the questions that you're mentioning and things to think about, that you would want to ask for any platform that has any kind of patient PHI information in it.
Right.
So hopefully that'll help a little bit to get them on their way. And of course, if you do have more specific questions, call in for a consultation anytime. Dan, I'm going to rush us a little bit to try to fit in a couple more here, but this question goes to you. A patient I haven't seen in 7 years reached out requesting that I delete her records in the therapy notes portal. Since 7 years is how long I'm required to keep the records, how do I make this decision? Would I need to delete all records that are older than those 7 years so that I treat all records consistently? Or do I honor her request? And Dan, you may also want to mention if they are deleted, how does that work in an EHR portal in terms of actual deletion rather than just, yeah.
Right. So quickly, in an EHR portal with deletion, you have to make sure you look at the program, Liesl, and see how to securely delete it, meaning that there'll be a way to actually write over the memory sufficiently frequently with random zeros and ones. There's a reason they call it digital, so that it's truly gone. It cannot be gotten again. There are two components to the question. I'll try to be quick. One of them is, well, can I just delete everything or should I just delete everything and have a standard idea, if I understood the question correctly, about after 7 years, everything goes, or can I be selective? You can be selective. The 7 years is a minimum, not a maximum. So if your client calls and says, I want it all gone, and you don't see any reason to keep it, let's say it's not a highly sensitive case, or a case where the client has been accused of a crime and it's wending its way through the courts, you may delete it, and you are not required to then delete the adjacent case where the person has more risk, or you're concerned about, for example, they may need this record or this assessment because now they're going away to college, and it would be very helpful to keep this record because it demonstrates an early identification of special needs for learning. So there isn't a uniform rule here. Generally a good idea, Liesl, to kind of say, okay, after 7 years, I destroy records and here are my exceptions. But that's when I say general rule, it's more kind of what is a traditional practice. There's no specific law that says we have to do that. And we also, one more piece is we do have to look at our particular state. Some states say 7 years. Florida says 3 years with 4 years of a summary. And so, you have to look at the particular state's requirements. Other states say just 5 years. Okay.
Great, thank you. Mark, any tips for responding to parent concerns about the possible autism registry? This clinician's been receiving more questions recently about whether they can or should destroy records, that kind of thing. So can you speak to that for a moment?
Yeah, it can be a really challenging conversation to have. And I think about this in two situations. One is new patients, or where you want to have this discussion up front, make them aware, because there are legal requirements to report in certain states currently, and there's some discussion about expanding registries at the federal level or in other states as well. So I think it's important for parents to be aware of this, what your legal requirements are, if a diagnosis is relevant and necessary to assign. I think that's another consideration. I sometimes have discussions with callers about the difference between the forest, the diagnosis, and the trees being the symptoms. And after all, we often do focus on symptom level. And so if a diagnosis is not absolutely relevant, then perhaps there's an argument for why it doesn't need to be included. And for existing patients that you learn about the existence of a registry, you want to have a frank discussion about what that means, what your requirements are. They may be disappointed, but this is one of those where you could take a stand. There may be some consequences, but legally you may be required to report in certain situations if there is a diagnosis or certain criteria are met. But it is a very challenging situation to be in when you have a patient who is pleading with you to put their privacy concerns above that requirement. It puts you in a bit of an ethical bind.
Yeah, and so that's great, Mark. I think you really gave some great response there. I'll just add again, that's where consultation is really valuable because we can also hear more about your particular situation, this client, and give you more specific advice. Sure. Because a lot of these decisions are going to have to be case related, right? We can give general information, but that's not going to go for every single case. So really good, Mark gave excellent information. And I would just add, please consult. Dan, can you, like, in 30 seconds or less, comment on the use of AI for diagnostic purposes after receiving an informed consent from the patient? Can you say anything about that?
If it's general AI like ChatGPT, et cetera, my 30-second comment is don't do it, even with informed consent. If it's going to be a specific program that's proprietary and you've reviewed their terms of service, their privacy policies, and the client has consented, then I think Mark's recommendation about very carefully reviewing the diagnostic impressions of AI and aligning and reviewing and making sure you're familiar with the literature on that particular area will still be important. The responsibility is each of ours.
Perfect. Yes, do a lot of homework. So on that note, thank you both to Dr. Martinez and Dr. Tao for another very informative roundtable.